Good morning, everybody. My name's Nils O'Donoghue. I'm one of the solicitors within our regulatory team, and Daniel's having the week off this week from the Monday Morning Dispatch, just so I can bring you a few data protection updates as well as a sports law update. Just to let you know, we are holding a mock trial at Headingley Stadium, which will be a mock trial concerning a health and safety breach with our partners Lighthouse. That is on the 15th of June 2022. We currently have over 100 people signed up to this mock trial, so places are very limited. So if you could go onto our website and book on as soon as ever possible if you do want to guarantee your place. Turning to the update, the European Data Protection Board has in the last week or so issued some new guidance in relation to how supervising authorities that issue data protection breach fines should calculate those fines in relation to EU GDPR breaches. I'm just going to use my tablet to go through those breaches as the rules are reasonably complex. So the supervising authority does have discretion in relation to the fine, but must go through 5 quite complicated steps. The fine should be effective, proportionate and what's called dissuasive in respect of ensuring that those who commit data protection breaches are punished to sufficient amount to dissuade others from doing so. The supervising authority should also give due regard to a list of circumstances that refer to features of the infringement. That means how serious is the breach, and also need to take into account the character of the perpetrator, be that the company or the individual that has committed the breach. The start of the document is quite typical of European legislation in that it's quite wordy and complex, as you can no doubt take from just that brief snippet there. Then the document goes on to state the 5 steps for calculating fines for infringements of EU GDPR. The first step is to identify the processing operations that have been breached, and that needs to be evaluated. And the second is to look at the fines table and look at the starting point for the calculation of the fine that needs to be identified. The third step is to evaluate the seriousness of the infringement that's taken place, and that's in light of the circumstances of the case, and that includes looking at the turnover of the undertaking, for example, that has committed the breach. The third step is to look at what's called the aggravating and mitigating factors in a very similar way that you would, for example, if you were in a magistrate's court in this country. There are sentencing guidelines for most criminal offences in this country, and at a certain point in those steps you are expected to look at the mitigating factors of the offence and an aggravating factors, and that's reflected as well in these 5 steps. You've also got to have a look at the past and the present behaviour of the offender. That's crucial. If you do have a poor GDPR record, for example, and breach EU GDPR, that would bump any fine that the supervising authority would levy. Equally, if you have a good record and have remedied things and put policies and procedures in place, that would be a mitigating factor that would bring matters down. The 4th step is what's called identifying the legal maximus for the different infringements, and the 5th and final step is to calculate the fine looking at the effectiveness, dissuasiveness and proportionality of the issue. So a very minor breach needs to be proportionate, and the fine should be within a reasonable remit that you would expect for a minor breach. Equally, if it's a large breach, proportionality will mean a much larger fine. Extremely complicated guidelines, and hopefully we will receive further guidance on those, and it'll be interesting to see how the ICO uses these guidelines and if they will be eventually reflected in the UK GDPR. Just moving on, the ICO has imposed a very significant fine, and particularly in light of these guidelines, it is appropriate to discuss that. It's actually an Australian company that the ICO has fined, and they have fined an Australian company £7.5 million, and the company is called Clearview AI Incorporated. It was actually a joint operation with the ICO's Australian counterpart, and that was for breach of UK data protection legislation and acquiring 20 billion images of people's faces and data from publicly available sources. including the internet and social media platforms. Particularly in light of the new guidelines for fines, it is highly appropriate to see that the ICO is working with its, first of all, overseas counterparts to impose fines, and second of all, not afraid to flex its muscles when it comes to punitive penalties. Finally, for those of you of a sporting disposition, there has also been an update from the government that a new regulator for football will be set up, and it'll be interesting, particularly for our sporting clients, to see how that develops going forward and whether that will then be reflected across the sporting sector. I hope you found that helpful. I appreciate it is a particularly complex area, GDPR, so if you do require any further assistance, please do let us know. Thank you.